Hello and welcome. Thank you for attending this webinar about civil protection orders, new forms and processes. I'm Ivan Sandoval, Customer Service Division Director at the King County Superior Court Clerk's Office. With me today, we have Hannah Service, who is the King County Clerk's Office Customer Service Supervisor, Susie Harris, who is our Customer Service Lead, Ross Zimmerman, Outreach Services Librarian from the King County Law Library, and Angela Ragnes, Legal Services Supervisor from the King County Prosecuting Attorney's Advocate's Office. This webinar is not intended to be legal advice to anyone, but rather is intended to provide a broader procedural understanding of new processes impacted by HB 1320 and 1901, newer civil protection order laws. We will start today with Hannah Service presenting about the clerk's processes for protection orders. Angela Ragnes will then talk about the advocate services and will share some of the impacts of the new legislation. Ross Zimmerman will also then share information and resources for those seeking a civil protection order and services provided by the Law Library. Please use the Q&A function to ask questions. Please do not use the chat option. We will do our absolute best to answer all or most of the questions. Lastly, this webinar will be recorded and posted on our website for future reference. Thank you everyone for attending.
Thank you, Ivan. There we go. Okay, I'm going to share my screen with you guys. Sorry, working through challenges. Okay, so like Ivan said, welcome to the webinar this afternoon. We are going to be discussing civil protection orders and the new process, new forms directly related to the clerk's office. So Susie Harris and myself work for the King County Superior Court Clerk's Office, and we're going to be going over the changes and direct impacts from our side of things. I wonder if I can move this ribbon or condense it. There we go. Sorry about that. Okay. What are some changes that took place on July 1st, 2022 that have impacted the clerk's processes related to civil protection orders? So there is new legislation that went into effect starting July 1st, 2022. This legislation is, and we have the RCW code, RCW 7.105, and it replaces the previous RCW related to protection orders. From these impacts, there is now a new combined civil protection order petition and order. So instead of 6 individual protection order types, we now have domestic violence, anti-harassment, sexual assault, stalking, and vulnerable adult all in one petition. There is also a law enforcement confidential information form, and this document is filed in the case once it's initiated, and it is a sealed document that will be provided within that case. Parties are now able to submit evidence or exhibits and present that at their full hearing for protection order cases. And denial orders, if there is a denial order that's entered for a temporary order for protection, petitioners may still be granted a return hearing date where they can then submit an amended petition within 14 days from the denial order being signed. So when a denial order is entered, there will be a return hearing set for that petitioner, the filing party. So that's just a very vague and general outline of some impacts that have occurred from January 1st, 2022. One cause of action, again, like I stated earlier, these are all the different protection order types that will now be listed on the petition. And we will be showing you what that combined petition looks like. There are still more changes that will be coming. What's coming January 1st, 2023. There will be e-submission process. So individuals will be able to electronically submit protection orders 24/7. There will be a notification system. Anybody who files a protection order, has orders granted, they will be able to receive notification of court hearings, if a return of service has been completed or filed. And like I said, next court hearings. And there will be more forms that will also be coming out effective January 1st, 2023. So you can now see the new combined petition form for civil protection order types. The combined petition can be used for any one of these protection order types: domestic violence, sexual assault, stalking, vulnerable adult, and anti-harassment. Under anti-harassment, there are additional smaller boxes that also qualify. So anti-harassment cases have subcategories, and the person who is filing, the petitioner filing for a protection order, will be able to select one of these options. And there is a brief narrative to the right-hand side of each protection order type that kind of gives an outline of what that protection order entails. For example, domestic violence protection order from an intimate partner or family household member who has committed domestic violence, non-consensual conduct or penetration, and unlawful harassment or stalking. This petition is 11 pages in total. There are additional attachments depending on as the petitioner completes this combined protection order type. If there are children involved, there are specific attachments that will go along with that. If it is a vulnerable adult, there are also sub-attachments that will accompany this petition for protection order. So we say that in that it's currently 11 pages, but it can be longer than that. And then this does not include ERPOs, and ERPOs are extreme risk protection orders. That is a separate petition, and we have those forms also available. So we just wanted to highlight that these are the general protection order types. But if you are interested in filing an extreme risk protection order, you would not complete this petition. This is the combined temporary order for protection. So now, instead of, after you complete the petition and you select the order for protection that you are seeking, you will then be able to use this temporary order for protection. And this can be used for any one of those previous actions that I just showed you. But for the extreme risk protection orders, that is truly its own cause of action. And we'll be able to go over that a little bit later when we show you our website. The court may issue a different order type than the one that the petitioner requested. So if I am a petitioner and I am looking to file a, let's say, domestic violence protection order, I would complete my petition and I would select the box for a domestic violence protection order because that's what I'm seeking. And when I go into court after I have my court hearing, if at that time the court determines that I qualify for a different cause of action, maybe anti-harassment, stalking, something along those lines, the court will have the authority now to be able to change that by using this temporary order. So they will be able to mark that it is actually an anti-harassment protection order instead of a domestic violence protection order. Here in King County, our petitioners must submit a proposed order when they are also submitting a petition for order for protection. So it's one of the required documents to initiating a case. You will have your petition for the protection order that you're seeking. And in addition to that, you will also complete this proposed order, temporary protection order. And this is truly what it is that you are asking the court to order. And then once you go into your court hearing, any changes that the court would like to make at that time, they will be able to do that. But we still ask that parties at least fill out the outline of the temporary order and what it is that you're requesting. So here we are, required documents when we're requesting a civil protection order. We need the petition, and that is the initial document that I showed you. So the petition for a civil protection order, the law enforcement and confidential information form. And this document is what law enforcement uses to enter any protection orders into the WASIC database system, and also to provide service to the other party. And a case information cover sheet. This cover sheet is what allows us, it lets us know what type of protection order you're seeking, civil protection order, ERPO, and also the designation, Kent or Seattle. So when completing this, it's very simple. You just check the box whether you are looking to file a Kent protection order or a Seattle protection order. And then the proposed temporary order. How to submit the protection order petition and other forms. So there's a couple of ways. I'm just going to turn on my do not disturb. Sorry about that. There's a couple of ways where parties can, anybody who's interested in completing a protection order, that they may do that with our office. Our office is open to the public. So anybody who's interested in coming into the courthouse, our Kent and Seattle courthouse locations are open. We open at 9 a.m. and available through 4:30 p.m. We also have a virtual protection order office. So we utilize the Zoom forum, which is what we're using now. And those hours are also 9 to 4 p.m. It does close during the noon hour for lunch. But you can receive the same service that you receive in person, you can have virtually as well. This is an example of what our current website looks like. And as you can see, our forms are also posted on our website. So if you go to our Superior Court Clerk website under protection orders, there are 3 items: civil protection order, and this is where you will find all the required forms that I showed you on the previous slide. You'll see all of those required forms to complete. You can either download, save them. You could print them and bring them into our office and we will walk you through the process, or you can do it from any space where you are and then visit us virtually. So you will fill out the completed forms, and then you can click on this blue computer icon, and that will allow you to come directly into our Zoom room. If you don't see somebody initially when you enter our Zoom office, don't worry, we do have a waiting room. And so typically we have 2 clerks that are manning this virtual protection order office, and they are the ones that are working with parties. And here is a link to our direct website. You will also notice if, for example, you maybe are not interested in filing the civil protection order and instead you want to complete the extreme risk protection order, you would then be able to click there, and forms available for that extreme risk protection order. If at any point in time from filing, you need to immediately shut down the computer or, excuse me, the website, we have a quick exit button where you can utilize that and it will immediately shut this down. So also any customers, we do same day initiations. So anybody who comes into our office from 9 a.m. to 2:15 in the afternoon, those individuals will be able to go into ex parte to have their temporary order for protection heard that same day. Anything after 2:15, our staff can still initiate that case, and we will send you instructions to go into the ex parte courtroom that following day. And that's what it states here. So customers submitting the required documents to the clerk's office, the petition, the KICS, the LECIF, and the proposed order, those are the required documents. Between 2:15 and 4 p.m., those individuals will have their temporary order hearing that next judicial day. And if it's on a Friday, then you would return on that Monday. Okay, so virtual customers. During the virtual visit with the clerk, this is what you can expect from us. Customers can share their screens. So you can, and then our office will create a share file link, and we will share that link with those parties in the virtual office. And from there, you will be able to upload any documents that you completed from our website, the petition, the KICS, the LECIF, and the proposed order. So we will be able to accept those via that share file link and initiate a protection order case. If an interpreter is needed, we are able to access interpreters as well. And then of course we have the ability to share our screens, our videos. And then if you do not have a laptop or computer, you can join it by calling in as well. And then we're always here to support you all. And even if, I do want to say, even if you aren't sure, you just have process questions, procedure questions, please join us virtually. If you do not want to come into the courthouse, you don't have to. You can go ahead and join our virtual office, and we're more than happy to answer any questions, processes, resources, anything along those lines. Okay, so now after the virtual visit, from when we initiate the protection order and give you a case, after we have done those steps, the customer, the petitioner, will receive an email from our staff with instructions on how to appear for your temporary order for protection. The temporary order for protection is heard in ex parte. And so we have a one-page sheet that will have a link or call instructions for that court hearing. And after you have your temporary order hearing in ex parte, the clerk, our clerk's office, will send copies to the petitioner of any signed order. So the proposed order that you completed, you will get certified copies from our staff. All previously submitted documents, so the petition, if there's a declaration or anything along those lines, you will also receive those documents from our office. And a 911 cover sheet, instruction cover sheet. And that cover sheet has instructions on how to ensure that the other party is properly served for notice of that next court hearing. And then also at the same time, we are providing instructions for how to submit evidence or exhibits for that final hearing. And in there it specifically lists who to contact if you are interested in submitting an exhibit. Exhibits are not required for that temporary protection order in ex parte. That hearing, you truly only need to submit your petition, any declarations that you want to file, and you can save any evidence or exhibits that you are interested in submitting for the final hearing. And then our office will also send any orders that were signed in ex parte. We will send those to the law enforcement agencies that are listed in that order for data entry and service. And we are required to do that same day or before the next judicial day. And then here are some resources for you. This is the telephone number for our Seattle and Kent Protection Order Office. We also have a live chat function. So if you want to, we have a link on our website where you can immediately correspond with the court clerk, and that is open from 8:30 a.m. until 4:30 p.m. and it does not close for lunch. So you can click on the link and you can type your question to us and we will immediately provide information, resources, anything along those lines. And then we also have an email address for our protection order office. So if you have any questions, if you're unsure about your court hearing, maybe you lost your instructions or you're looking for your, petition, anything along those lines, you can email us and we can send those to you. And then always our virtual office is open too. So, and then here's some names of individuals. You have myself, Hannah Service. I'm the customer service supervisor, and I primarily work in the downtown Seattle courthouse. And this is my direct email address. You have my lead, who's my assistant. If I'm unavailable, he will jump in to help. His name is Robert Bell with his email address. Susie Harris is the Kent lead as well, and her email address. And then you have Yvonne Sandoval, who is our division director, and his email address. I'll just give it a couple minutes in case anybody, or 30 seconds in case anybody wants to write this information down. And I think from the meeting invite on Zoom, you also have my email address. So if any of this information kind of gets lost along the way, don't worry, you can just reach out to me and I'm happy to send anything over to anybody. And this is directly for the clerk's office. Are there any questions or comments? See some. Okay. Okay, so there is a question in the chat, King County Superior Court and not King County District Court. That is correct. We are strictly talking about King County Superior Court cases. Thank you for asking that question. Our office does not have jurisdiction over district court cases. So if and when you do come into our office and you're looking at filing a protection order, we will be able to ask jurisdiction related questions to identify if you would qualify for a protection order in Superior Court or District Court. Let's see. And somebody was asking, thank you, will these slides be available? And yes, I can make this information available to you all.
And it looks like there's a question from Ronald regarding the LEIS that we don't keep in file. That's why they don't get them. And we don't hold on to them. So I'm not sure why they indicate that in their question.
So it says a lot of the petitioners calling our office to help with service of their temporary orders have had their LEIS form held by the court for some unknown reasons. I had to send many petitioners or hand a copy of the counter, a blank LEIS to fill in. They all keep saying they already have one out, but the court didn't give it to them. So prior to this new legislation, there was the LEIS, and that form we were not able to hold or to retain that document. And truly law enforcement uses the LEIS to process these orders for WASC and service. and our office was not able to hold those within the court file. And so it was relying on parties to have the LEIS and to provide that at the time that any orders were being entered. And then we would forward that to law enforcement. The really great thing about this new legislation is we no longer have to do that. We have the LECIF. So hopefully going forward, this won't be a big issue anymore. Because we will be able to have that LECIF filed into the court file. It will be a sealed document. And that sealed document will only be able to be accessible by parties by court order. Otherwise, we will be able to take that and forward it to law enforcement.
And then Hannah, we may wanna move into the next presenter, but I wanna answer this last question. So there's a question from Monique. You said if the temp order deny, we may have a return hearing anyway. Is this automatic or does a full hearing have to be requested? So the court decides that. The court will decide if, in most cases, everyone who has a denied order will most likely have a return hearing. There will be some instances where the court will deny the temporary protection order and will dismiss the case as well. But I say that in most cases, mostly everyone with a denied order will still have a return hearing date for them to come back, and will still have 14 days to file an amended petition. So we'll keep answering questions, and then I think the next presenter is Angela.
I think you're muted.
Good. Okay, Hannah, if you could just give me a thumbs up that my screen is sharing, that would be awesome. Okay, so I'm Angela Rognes with the Protection Order Advocacy Program. There were a number of changes introduced with this new legislation, House Bill 1320, and then the additional Trailer Bill 1901 that then turned into RCW 7.105. It's an over 300-page piece of legislation. So there's a lot of changes. And I encourage people that are really interested to definitely go online and read it in depth. I'm just going to talk about the changes that our program anticipates to being the most impactful for our petitioners. The first, Hannah already kind of alluded to, the form. Combining one universal form is huge for petitioners because most attorneys are going to know what action to file. Pro se litigants, and this is a system designed for the pro se litigant that's coming to file a civil protection order. If they're at that stage, something in their life is going really wrong. People don't seek protections from the court just on a whim or just as something to do. Something is going on that's causing extreme fear, anxiety. So you have somebody coming to the courthouse virtually or in person that may not be able to fully understand all of the forms, to read all the definitions and make a quick choice of what order they should be filing. Now that there is a combined form, if someone under that kind of duress and pressure accidentally checks the wrong box, when they're seen by an ex parte judicial officer, the court can change it to the correct box that fits their situation and their relationship. Instead, before this legislation, the remedy would be, I'm so sorry, sir, ma'am, you filed the wrong order. Start over, and then you would get a new set of packet forms to fill out, which a lot of people at that point just want to quit this process. Okay. Our program is limited to the folks that we serve. We're able to assist survivors of intimate partner violence or those that are filing on behalf of a minor against a parent. Many more folks can file for protection orders, but due to staffing and limited resources, we're able to focus on assisting that relationship in filing and through the court process. The clerk's office helps and processes everyone's paperwork. And in King County, the last 3 years, that's an average of almost 3,000 domestic violence protection orders a year. And remember, there are 5 other different kinds of protection orders. So please be assured that the clerk's office in King County is working incredibly hard, and they have do an incredible amount of work each and every single day. Our program is limited that we are able to focus on folks in particular situations. We have an advocate team based out of the Kent courthouse and then also the Seattle courthouse. Right now, almost everyone is working remotely. We are transitioning soon to be able to do in-person appointments for those folks that just have a harder time accessing our services remotely. But we do respond to a number of phone calls and emails from folks in a variety of situations. And then we do give them information on what order that may fit their situation. We cannot provide legal advice, but we might be able to steer them to what we think might fit their situation, give them some general instructions on how to file. And then also, if we know of any specific resource information for their situation, we'll provide that as well. So who qualifies? This is a big change. You have all the ones that we've had in the past. A big change now, and this was kind of a hole in the protection order for who qualified, is many times people would come in and they'd want to file against, on behalf of a child, against mom or dad's new partner that lives in the home. And they would think, okay, well, the only situation that fits is roommate. Many of our judicial officers interpreted that a child does not have a roommate relationship with another adult. So that was kind of leaving people with not able to file because there wasn't a harassment level concern, and it wasn't necessarily a sexual assault protection order, but then they didn't know what to file. So that's been corrected. Now a parent can file on behalf of their child against the other parent's intimate partner. Another big change is jurisdiction. Previously, if people are encouraged to file in the county that they live. They can also, were able to file in King County if they were filing on behalf of a minor and that minor primarily reside in King County, or a petitioner could file in King County if they lived here but fled King County because of the abuse of the other party, or fled to King County because of the abuse of the other party. The new part is that a person can file in King County if the behavior happened here in King County. So they can live somewhere else but still file here. Our advocate team is curious to see how many people take advantage of that and how many people we start to see file in King County because of that. Another big change that happened very soon after the pandemic, we had several emergency orders coming from the governor and the Supreme Court that were allowing electronic service. This was great because in the early days of the pandemic, officers were very concerned about trying to do personal service, going to all these homes to serve these documents at a time when public health is saying, nobody leave your home, nobody go out and go to other people's homes. So electronic service was authorized, and that's been fantastic. Early studies also show us that, and this is early, but it will be studied more, that it's also increasing respondents' attendance, because they're being served in a way that is in some respects a little bit more respectful. Like there's not an officer showing up at work and trying to serve them or serving them at home. They're just getting an electronic notification, and people are checking their email far more than they check their regular mail. And that was causing them to come to these hearings and participate, which is great because all parties participating results in more just outcomes. There is still personal service required in certain situations, and these are all centered around safety. If an emergency order says the other party must surrender firearms, law enforcement should be trying to personally serve that to secure those firearms and to be safe. If the order says that the other party has the children and they need to be transferred to the petitioner, law enforcement should be doing personal service. Same thing if someone's being told to vacate the shared home, and if the respondent is incarcerated, which makes good sense because if you're incarcerated, you may not have regular access to email. And then a big change for our program that advocates have both been excited about, but also frankly very nervous about, is that the domestic violence definition used for protection orders has been expanded to include coercive control. Now, advocates for a long time, community system-based, have always described to folks that socially domestic violence is recognized as a wide range of behaviors, but the statute was very, very narrow, focusing just on actual physical harm, threat of physical harm, sexual assault, or stalking. Now it's been expanded to include coercive control and unlawful harassment. It will be very interesting to see how the court interprets this, and what the burden of proof in all protection order hearings is preponderance of the evidence, so more likely than not. I've seen many commissioners describe it as like a 51% proof. You know, if you're a petitioner and you persuade the court by more likely than not 51% that domestic violence has occurred, then they're going to grant the order. It'll be interesting how coercive control falls in there. We're already starting to look at it as it helping a petitioner write their narrative when there's just been stalking behaviors. Providing context is so important, because very often stalking incidents or coercive control incidents just by themselves can almost seem really normal, and it's hard to, well, what, they sent you flowers, what, that seems nice, what's the problem with that? But putting in context, like, oh, I always got flowers, you know, after XYZ happened. They really have to help a petitioner explain, like, what is that particular act that makes you fearful? Or as the coercive control edition says, what about that act unreasonably interfered with someone's free autonomy and ability to make their own decisions. So we haven't yet, I mean, this just went into effect July 1st. We haven't really seen this play out in the court yet, but advocates are very interested to see how the court weighs this. And it's definitely going to take more time for judicial officers to really dig into it and get the nuances of what's going on in that relationship, and not just a list of acts, but like, what about those acts rise to the level of coercive control? So that's it in a nutshell. But again, this was a 314-page piece of legislation modernizing and harmonizing a number of processes. Any questions, please reach out to our program. And I think we'll have time for questions after Ross gives us an update on library resources. But again, lots of information. So I encourage you to reach out to our program. It's protectionorder@kingcounty.gov if you want to send those questions to us.
I think there are a few questions before we probably Angela. So one of the questions is there a handout? I believe it's a handout for your program, related to your program.
Yes, I will have to send that probably to Ivan later, and then maybe he can send it out to you. Yes, but that's a great question. I should have been more prepared.
And then when will you be transitioning to offer some in-person services?
We are hoping to do that the week of August 1st. And to start, it will be all advocates are in court in the morning. And then in the afternoon, from 1 to 4, we'll have by appointment only.
And then the next question is, if the new statute requires that entry of a protection order necessarily requires a weapon surrender order, and if the weapon surrender order can only be served by law enforcement, are judges and commissioners going to accept service of a protection order by electronic service if the weapon surrender order has not yet been served by law enforcement?
That's a really good question. And I think it's going to depend on the judicial officer and at what stage the case is as well. If law enforcement has tried to serve that order to surrender weapon at least twice, then it's my understanding the court will accept electronic service. But that main part is around safety, so that if there are firearms, that law enforcement can safely help that person surrender them and secure them. But if like the person has found out about the order and maybe given that the firearms to family members or something like that, that reduces the safety risk, then the court may accept electronic service. But again, it's going to depend on the specific judicial officer.
Yeah, and then lastly, if law enforcement is unable to personally serve a Dvpo, can the petitioner's attorney serve the respondent electronically where there's no order to surrender weapons? Am I understanding that correctly?
Oh yeah, absolutely. And that right now, the statute is assuming that service by email is the preferred method if it doesn't include an order to surrender, transfer of child, or vacating. And sometimes our advocates will electronically serve a petitioner, and that you don't have to have a specific order to do that. You'll just want to make sure you're serving all the documents, you're keeping the email you sent the other party. If you're able to get a read receipt or any response, you should include that in your proof of service document as well as just a best practice. Great question.
Yeah, and then welcome, Raz. It's your turn here.
All righty, thanks everybody. I do not have a slideshow. I'm just going to be talking. So first I want to tell you a little bit about the law library itself. So we have 2 locations. One is in Seattle where I'm located. The other one is in the Kent Courthouse down there. So our hours in Seattle, 8 a.m. to 4:30, Monday through Friday. And in Kent, it's 8:30 to 4:30 with a closure in the noon hour for lunch. We aren't attorneys at the law library. We're not practicing attorneys, and so we can't provide legal advice, but we're here to point you to resources. So resources could include online resources, which I'll be talking about in a second. Of course, we have a lot of books. We have like 43,000 books. And external agencies. We can point you to agencies or maybe a free attorney clinic, things like that. We also work with attorneys to put together form packets. So we have like a lot of probate, if you're going through probate, how to file a will, that sort of thing. So those are available for purchase on our website. But what's of note for this hour is that we have a packet for domestic violence sealed name changes. And so that's available for free on our website. So if you're going through it, you need to seal your name change. Go on to kcll.org and read a little bit about that. We also on our website, we have videos, we offer webinars like this and a lot more. So come by and say hello or send us an email. We're happy to help on the phone or via email. One thing that I wanted to talk about briefly for the sake of this hour, when I did my first protection order webinar probably 2 years ago, something that I wasn't super cognizant about and was that some local agencies impressed on me is the importance of safety planning. I'm aware that there's a lot of agencies and organizations on the call, so you're probably, of course, well versed. But for members of the public and individuals, self-represented litigants on the call, I wanted to discuss safety planning, which is another avenue for increasing safety and responding to violence. Protection orders, of course, are a valid and often very necessary response to abuse, but they aren't the whole picture, right? There are other considerations in such situations. So again, safety plan is going to be well known to the organizations and the agencies on the call, but if you're experiencing violence or threats of violence, or you're just concerned about your welfare or the welfare of somebody that you love, safety plans are a way to prepare for the possibility for more violence or threats. So safety plans are, they're just that. They're a plan, which it could be written or maybe it's just otherwise, committed to memory, but it's going to detail how you escape a threatening environment, what you can set aside so that you can easily grab it and go, how you could stow money away, who you could rely on if you needed to go somewhere, if and when you decide to leave. The specifics related to children. So it could also include, getting an order of protection. It could involve getting a divorce or other legal solutions. These are all highly personalized, right? Everybody's situation is different. There's a lot of resources on the web about safety plans. If you start Googling, there's a wealth of information, but ultimately I recommend calling an agency to get personalized assistance. Everybody's circumstances are very unique. It's worth talking to an advocate who's just a phone call away to talk about your safety plan. So as far as agencies, on that note, I'm going to put into the chat, so not the Q&A box, but the chat itself. One second. A couple more seconds. Okay, so I just sent into the chat a list of agencies that can help with safety planning, or if you're just seeking protection orders, and a lot of adjacent organizations that if you're otherwise, affected by violence or threats of violence, harassment, this is a great group of people to talk to. In the 2.5 years that I've been working for the law library, I've kind of run into these agencies and been recommending them to folks who come into the library. If you're a relevant organization on the call and I happen to miss you in the list, I'm sorry. Feel free to send me an email, ross.zimmerman@kingcounty.gov, and I'll add you to it. But this is just something helpful to have on hand if you're needing more people to talk to. You have if you have individual needs or something like that, take a look at the list. For resources specifically for protection orders, with the forms and the changes being so recent, I'm really only aware of one online resource that's going to detail the process step by step with guidance on like how to fill out the forms. And so that is through Washington Law Help. Washington Law Help is it's a nonprofit website run by attorneys, the Northwest Justice Project. They have a lot of form packets on their site that detail, parenting plans, divorce, all sorts of things, but they are on the ball and they provide a great packet on their website. So it's the one I'm thinking of for protection orders. It's a packet with the details, the different types, but they also have other packets that talk about like restraining orders if you're going through a divorce or something like that. They have guides such as, should I file a domestic violence protection order? These are all incredibly helpful in the library, where we can't provide that kind of hands-on assistance, or we can't provide legal advice. Washington Law Help is a great resource. I do find it a bit tedious to get around. So depending on what you're looking for, like if you're looking for that protection order packet, I usually recommend that people just type into Google Washington Law Help protection orders and let Google figure it out. And it should pull up that form packet right away. But the protection order packet is extremely helpful because again, it has all the forms that you need to start the action, and it provides an incredibly detailed level view of, in this blank put this, in this blank put that, walks you through every stage and what to expect overall. It's incredibly helpful. Outside of Washington Law Help though, our books are pretty much out of date, right? These changes are so recent that, and it's also true that for a protection order, these are so individual and procedure focused that usually I don't even recommend books, because who wants to read, some lawyerly treatise on it? You kind of just want to know what to do next. But on that note, we do have like Westlaw in the library, which has more up-to-date ebooks. So that will be helpful for broad strokes, but ultimately, again, for people representing themselves, I'm going to more likely than not send them to an agency or to Washington Law Help so that they can kind of get to the point and do it themselves. I wish that I had more resources, and as time goes on, I'm sure I will. I'm just really grateful to the protection order advocates and the clerks for all that they do for petitioners and us in the courthouse. I'm happy to field any questions that you have about the library for Q&A, and otherwise, thanks a lot for having me.
I think the document you share, Ross, I think the chat is disabled for the one who joined us. So what we'll do is Hannah and I will send out a follow-up email to everyone who attended today, and then we'll include the materials from today's presentation there. There are many impacts from new legislation regarding civil protection orders. And as you can see, it's impacting our resources from the law library, it's impacting the advocate's office, and it's impacting, obviously, the clerk's office as well. And most importantly, it impacts those petitioners seeking for a protection order. We're happy to help in any way that we can. Join us if you have, if you need help, or a pro se or an attorney is filing for a protection order case. You're welcome to reach out to us through our virtual office, through the phone lines, or coming into our office. I will say that about half of the protection orders currently filed at the clerk's office are filed through the virtual office. So that has been a success for us as well. Let me see if there are any other questions. Is there any information on the website about filing a response or forms for responses? I don't think there's any information related to that on the clerk's website, but I assume there might be potentially on the Washington Court's website, or maybe even at the King County Superior Clerk's website. Is that right, Hannah?
Yeah, you could, there's information on the Washington State Court forms under protection orders. Parties could also complete a declaration and file your response within that declaration and submit any materials you would like for that return hearing or final hearing.
That is on my wish list of like a Washington Law Help type article for the response. But unfortunately, I don't know of any kind of detailed packet that goes into it.
I don't see further questions. So, one more question. When seeking to modify a Dvpo, do we also use the virtual platform? You want to answer that one, Susie?
You can use the virtual platform if you're comfortable with that, but you can also come in person. But the modifications, reissuances, or renewals, and all that can be done either in person or through our virtual office.
And then correct me if I'm wrong, Hannah, I think we had a conversation about this about a week ago. When they're seeking a modification or termination of a protection order case, except for ERPOs and vulnerable adults, they also have to submit to the King County Clerk's Office an adequate cost form. Is that correct?
The respondent, yes.
The respondent, if they're respondent, that's true. I gotta make sure I do that. Yeah, if they're respondent, yeah.
Yes.
Okay, I don't see more questions. So I thank everyone who participated in this webinar today. Thank you very much. And then we have 2 more webinars. The next one, it's August 17, same time as today. It's about minor guardianships. And then the third webinar, it's adult guardianships, and that's September 21st from 12 to 1. If you want to attend those webinars and register for them, you can always visit the Law Library website or the clerk's website, and the information is posted there for registration purposes. Thank you, everyone, and have a great afternoon.
Thanks, everybody.
Thank you.
Have a good day.